Alrighty. Good morning, everyone. Thank you for being here. My name is Lexi. I'm the moderator. Throughout the presentation, if you have any questions, feel free to send them my way, and then I will get them to Pam so that she may answer those at the end of her presentation. I hope you know that you are listening to Opening Doors, Equal Opportunities in Housing, and our presenter is Pam Bean. So Pam, go ahead and take it away.
Okay. Thanks, Lexi. See if I can get this set back up. I'm not exactly technology oriented, so I'm probably going to stumble through this, and I apologize ahead of time. I want to thank you folks for attending this session, and I will try to quickly share some information about non-discrimination laws at the federal level and state level, and then remind folks that communities, individual communities across Montana, also have local ordinances with additional protections. I work for Montana Fair Housing, worked here now 26 years. Our contact information is there on this screen, and that email address will reach me if you have questions in the future after this presentation, or we're not able to adequately devote the time in the 45 minutes we have to answer all of your questions.
Pam,
yes.
We can't see the PowerPoint.
Oh, okay, so what did I not do? It was, because she had to turn it off for her DiverseU wrap. Okay. Sorry, folks. See, I told you I'm not electronically inclined. Okay. So there's the contact information. Hopefully everybody can see it now. I need to let you know that I am not an attorney, nor is anyone that works at Montana Fair Housing an attorney. So I can't provide you legal opinions on the information that I'm sharing. Just explain to you what I understand the law to say and potentially some case law interpretations. Montana Fair Housing is not a governmental entity. We're a private nonprofit serving the state of Montana. We do a lot of education and outreach like this event. We also do some dispute resolution services if folks are hoping to resolve an issue sooner than later, as the filing of complaints and investigations from HUD, HRB, or in court can potentially take years. We also do investigation and enforcement as those activities relate to discrimination in housing. The one law I want to make sure everybody is aware of is the 1866 Civil Rights Act, which prohibits discrimination on the basis of race and color. And unlike all other non-discrimination laws, this law has no exemptions. So no matter what the transaction, no matter what type of housing is involved, race and color can never be a factor, or should never be a factor, in the denial of housing opportunities. The Federal Fair Housing Act includes several protected classes. Race, color, national origin, and religion were part of the law in 1968. In 1974, sex was added, and then in 1988, the law was amended to include protections based on familial status and disability. At that time, it also created an administrative enforcement system, which allows victims of discrimination to file complaints with Department of Housing and Urban Development or the Montana Human Rights Bureau versus going into court. Prior to 88, if someone wanted to enforce their rights, they had to get an attorney and go to court. At this time, the law also included civil penalties, which a judge can assess at the end of a hearing or process to recoup monies that the United States government has had to spend in pursuing complaints of housing discrimination. So if it's the first time someone has been adjudicated of committing discrimination in housing, the civil penalties can be as high as $21,410. If there's one prior in 5 years, it can be as high as $53,524. And then within a 7-year period, $107,050. Now, it doesn't have to be that high. The judge has discretion, so it might be 1,000. But these are only the civil penalties paid to the government. Victims of discrimination can also get, for example, compensatory damages, damages for emotional distress, punitive damages. So it's a pretty broad range, and violations of the Fair Housing Act can have pretty severe consequences. In the state of Montana, in addition to the federally protected classes, we also have marital status, age, and creed. So I want to take a second and just describe to you briefly what each of these protected classes cover and prohibit. Race references not only the color of someone's skin, but also cultural inclusions. So someone might be Black and be from Africa, but they might also be Black and be from Jamaica, and those are very different cultures. So an allegation based on that might include race versus just color. National origin references the country someone is from, or potentially their ancestors are from. So like if somebody's from Mexico, it may be a national origin complaint as well as a race or color complaint. If they're from Germany, it may be national origin. If someone is native and a member of a tribe, then that would also be national origin because the reservations are considered sovereign nations. Religion is the participation in or lack thereof an organized religion. So if someone's Catholic, they couldn't deny someone who doesn't participate in organized religion at all, or deny someone who's Seventh-day Adventist. Sex is whether you're male or you're female. It also provides protections for domestic violence victims. If those victims are female, because statistically, the most frequently reported domestic violence incidences are by women. It also prohibits sexual harassment in housing. And I want to note that this past 6 months, our office has received more complaints about sexual harassment than we have in a number of years. And I think because of the housing crunch, limited housing availability, limited affordable housing availability, coupled with the pandemic on top of that, housing providers are more apt to be able to make choices, discriminatory choices about who is going to be eligible for their properties. Familial status covers only the presence of children in the household, whether that be adopted, natural born, foster parenting, and it also prohibits discrimination on the basis of being pregnant. Disability covers both mental and physical and emotional disabilities, provides for accommodations, modifications, and also the design and construction of new multifamily housing after 1981. Marital status means whether you're married, you're unmarried, you're divorced. A housing provider cannot discriminate against a household on that basis. Marital status is one of the more common allegations our office gets in as well. We often hear stories such as a housing provider doesn't want to rent single women because they don't mow the lawn, they don't take out the garbage, they don't control their kids, those types of statements. Age. A housing provider in the state of Montana cannot establish an age group that they will only serve or an age group that they will deny serving. So when we get allegations in about a housing provider who said they don't want to rent to students, for example, we will look at the average age of college students in that community and potentially be able to address the discriminatory activity as a violation based on age, because students themselves are not a protected group. And then creed is a strongly held belief system. Okay, I want to touch a little bit more specifically on disability, as we get a lot of calls about what these provisions cover and don't cover and how they're covered. So the definition of disability in the Fair Housing Laws is a physical or a mental impairment that substantially limits one or more major life activities. It can't be, say, an allergy that's just an irritant. It can't be moving from home to college and the adjustment period that occurs with that. It has to be a long-term impact that substantially limits major life activities. Most folks with disabilities have a historical record of that impairment. So usually they can prove, for 20 years I've been treated for this limitation. There's no question about that. Sometimes folks may have had a limitation, say during high school, but that was treated because of new advancements and they no longer have that limitation. But for some reason, the housing provider is making decisions about that person's eligibility because of the housing provider knowing that person in high school, for example. And sometimes folks have never had a disability, but the housing provider believes there's one and therefore makes decisions based on that. I think I've never seen an incident in the third prong of the definition except in employment, where employers will see someone looking sick, looking tired, and assume, for example, they have AIDS or that type of thing. The Another thing to remember about the disability provisions is they also cover visitors with disabilities. So if you have a family member or a friend who is coming to visit and that family member or friend has an assistance animal for emotional support, you have the right on your friend's behalf to request a reasonable accommodation to waive the no pets rule. Now, the friend will have to provide the verifying documentation if the housing provider wants it, but they do have the right to make that request. Disability provisions do not protect sex offenders by virtue of that status, meaning if someone is trying to argue that because of their disability, he or she is deemed a sex offender, that does not negate the danger of those actions. So an accommodation would not need to be provided, for example, to waive criminal record histories because of disability. If they're a danger, they don't have to, the housing provider doesn't have to waive that. It does not protect people who are currently engaging in illegal use of controlled substances. So if you're using coke, I don't know what drugs are, drugs of choice these days, sorry, but back in my day it was coke. If somebody's using coke and they get arrested, the housing provider can evict that person from the unit. Now, if the person is in recovery and was arrested 3 years ago for that use of coke, they can ask for an accommodation to waive that part of the application regarding criminal convictions on the basis of disability, and then show the housing provider they've been active in a recovery program since that time and been compliant. Finally, the law does not protect any individual with a disability whose tenancy would constitute a direct threat, unless that threat can be mitigated, maybe through medications or some other form of treatment. Okay? I've thrown out the term reasonable accommodations a few times. Somebody with a disability can request a reasonable accommodation, which is an alteration to rules, policies, procedures, practices that will allow a person with a disability to use and enjoy the unit and also the public and common areas. Accommodations can be a wide number of things. They can be requests for assistance animals for emotional support or therapeutic support. They can be requests for service animals. They can be requests for reserved parking spots, switching of units for a disability-related reason. Can be a number of things, as long as the request is related to the disability and will ameliorate impacts of symptoms. Requests for modifications are physical alterations to a dwelling that somebody might need, generally because they use a wheelchair for mobility, maybe a walker, maybe a cane. For requests for modifications, if the household is not, or if the units are not receiving federal funding, the housing provider can require the household pay for the modifications and require that the household deposit monies in an interest-bearing account to restore the modifications to original condition at move out. Now, if these modifications would not interfere with the use of the unit by someone who did not have that disability, the housing provider cannot require restoration of those modifications, nor restoration of exterior modifications. So, for example, if a household includes a person in a wheelchair, requests a ramp put at the front of the door over the two-step entrance, and that the doors be widened on the interior of the unit, and that cabinets in the bathroom and the kitchen be open so that somebody in the wheelchair can access things in those cabinets easier or slide underneath them. Now, at move out, what would be a reasonable expectation for restoration if the housing provider wanted restoration? My argument would be not the ramp at the door. That needs to be left. That housing provider could ask that the cabinet doors be replaced, put back on. But the housing provider could not request that the doors that have been widened to 36 inches be restored back to 28 inches, because almost any following resident that I've ever met is going to like the wider doors. It makes the unit more marketable to have the wider doors. The housing provider can require the household purchase appropriate permits and have the work done professionally. And I would encourage anyone who has set up to have modifications done that there also be something clear in writing as to what's going to take place at move out. Because if the household lives there 5 years, there might be a change in management or something. And if the housing provider had said, you know what, we're not going to require you to make any modifications at move out or restorations at move out, you want to have that in writing so there's no argument by any new management that may be there. So for a request for an accommodation or modification, what can a housing provider ask or not ask? One of the things I think folks often confuse fair housing laws with is the Americans with Disabilities Act and or our state public accommodations laws. And they have different applications and different applicability given the type of housing and services at the housing. And today we're talking about the fair housing laws. So if somebody's requesting an accommodation or a modification, the housing provider has a right to be clear about what's being requested. I am requesting an accommodation to your no pets rule for an assistance animal for emotional support. Let the housing provider know what kind of animal. Okay, you're wanting a cat, a dog, an iguana. What is the request? And if it's going to be for a dog, clarify what size of dog you are going to need so that there isn't an issue when You pick the dog, you bring it to the site, and come to find out the insurance policy at the site doesn't allow shepherds or Rottweilers or Dobies. There's what I call a hit list insurance companies have on breed and size of animal. So you want to clarify any of those types of questions that may come up about your accommodation request. If you're asking for a miniature horse, a duck, a chicken, an iguana, check with your state or your local ordinances to see if those animals are prohibited. And if there is a disability related need that you need that specific type of animal, then you will first have to make a request for an accommodation from the city before the housing provider can approve it, because otherwise the housing provider will start getting fines from the city. So be clear about what you're needing. I need to move from an upstairs unit to a downstairs unit because I have MS symptoms, and you don't have to tell them specifically what your disability is either. You can indicate your mobility limitations are making it more difficult to do stairs. So you need a ground floor unit, or you need a parking spot reserved on the closest route to your unit because you cannot walk that far anymore. So you have to have a disability to be eligible for an accommodation or modification. The housing provider, again, doesn't have a right to know your diagnosis, but they do have a right to know what limitations you're experiencing that relate to this request. So if you need the reserved parking spot and your disability isn't visible, maybe it's one like MS, for example, that can come and go as far as the limitations. You would need to get verification from your doctor that you have a disability and that mobility is limited and that the accommodation is necessary to minimize the impact on your major life activities. So hopefully this is all making sense. Now, sometimes disabilities are visible, so you don't need verification of disability, but it might be unclear why you need the accommodation or the modification. So you would just get clarification about that. If you're receiving some type of benefits that are for persons with disabilities only, then obviously you have a disability and you don't need to verify disability, but you might need to provide information clarifying the need for the accommodation or modification and specifically what you are requesting. The disability provisions also established in 88 design and construction provisions for new multifamily buildings of 4 or more units. Now, if the building has an elevator, then every floor that the elevator serves is also covered. But these are not accessibility requirements like are included in the ADA or in Section 504. For persons in a wheelchair, these requirements just make the unit usable. So they need to have accessible parking and an accessible route to the building. And the doors need to have a 32-inch clearance so somebody in a wheelchair can get in and throughout the dwelling. Any environmental controls like light switches, thermostats, electrical outlets from a side approach can be no higher than 48 inches, no lower than 15 for operable parts. They do not have to install grab bars in the bathroom, but they need to ensure that reinforcement is around the toilet and around the tub shower unit so that grab bars can be safely installed. And then the kitchens need to be usable as well as the bathrooms, allowing just enough room to maneuver, pretty much pull forward and back out. The faucets need to have lever handles, and the doors underneath the kitchen and bathroom sink need to be able to come off easily, and the floor be finished all the way to the back. So if someone needed to remove those doors, it is finished and looks like that was the intent. A couple of other things I just want to quickly throw out. The Keating memo addresses occupancy standards, which are limits on the number of people who can reside in a unit. Most communities have their local ordinances, but it can be no stricter than Keating. So if a housing provider wants to establish an occupancy standard, in short, that means 2 people per bedroom could be allowed to live in the unit. Now, if the unit has what they call a bonus room, like a den or a family room in addition to the living room, as long as those rooms have compliant egress and ingress for safety, then the household can also use those rooms as a bedroom. So it might be a 2-bedroom apartment, but have that den, so 6 people could live there and still be within the guidelines of Keating if a housing provider wants to establish those. They don't have to establish them, but they have the right to. Also, babies are not counted towards an occupancy limit until they're turn 3 years old. So if a couple is living in a studio apartment, which is considered a 1-bedroom, and they have a baby, they cannot be evicted the day they bring the baby home. Harassment by neighbors is a tough one. But as an FYI, especially under our state Human Rights Act, if someone is harassing a household based on that person's or that household's protected class status, say race, then that neighbor can be named in a complaint of housing discrimination. The housing provider, if that person is aware of the harassment, has an obligation to intervene. However, if it's single-family houses, for example, the housing provider might own the home you live in, but not own the home of the neighbors, so their control of what's going on with the neighbors is very limited. But just so you know, other tenants, other neighbors can be named in complaints of housing discrimination. And I apologize for my dog whining in the back here. Nuisance orders and crime-free housing. A lot of homeowners associations, for example, are putting these in place, and they can be problematic in regards to how they're implemented. So, for example, I mean, we all want to live in places free of nuisances, free of crime, but say a domestic violence victim moves into the homeowners association and the offender continues to violate the order of protection and return to the site, so she has to frequently call the police for protection. But the crime-free housing rules say if you call the police more than 3 times in 6 months, you got to move. That violates her rights to protect herself and other household members. Nuisance orders, issues arise around that, particularly for older persons and persons with disabilities who may need to call an ambulance frequently, and neighbors start complaining of it being a nuisance. So implementation of these guidances can be a problem. There's other laws to deal with nuisances and with crime. I'm not so sure why they're that valuable in the first place. Applicants with criminal records can be denied housing based on the fact they have a criminal record. However, applicants do have the ability and the right to request that a housing provider do a risk assessment. Persons with criminal records are not a protected class, but studies nationwide clearly show that people of color are arrested, charged, and convicted for crimes much more than white counterparts who are arrested for the same or similar types of incidents. So HUD's issued guidance in regards to this topic, indicating folks can ask for a risk assessment, wherein information would be provided to show what the person was convicted of, the compliance they've made in any order by the courts as far as treatment maybe, that type of thing, how long they've gone without additional offenses, the status and discharge status. So there are some options to overcome that. I think if somebody was busted for pot 10 years ago, no other crimes, I think we can easily argue that the risk involved, one, with the original crime, but two, even to this day, the risk to person or property would be pretty non-existent. Real quickly, there are protections for persons who have immigrated to this country, and there are ways for them to make application and be eligible for properties, even though they may not have, for example, a social security card. There are a number of people who live in this country, born and raised in this country, who don't have social security cards. So there's ways to run background checks, etc., to assist them in being qualified for different units. I also want to mention that if someone is living or looking at living in federally subsidized properties, Section 504, Section 508, and the Americans with Disabilities Act is going to provide additional coverages. So if you have questions about that, you can email me, you can call us, whatever. All transactions are covered. A lot of folks think that only properties receiving federal funds are covered. The non-discrimination laws provide protections for persons in protected groups in all types of transactions. It could be mortgage, it could be lending, it could be appraisal. Decisions can't be made based on protected class status. We see a lot of different types of practices, usually different terms, conditions, or privileges. You use a wheelchair, so we're charging $400 more for deposit because we know wheelchairs cause more damage. You have kids, so we're going to charge you an extra $100 per month per child. The kids can't go in the swimming pool unless supervised.
Pam?
Yes.
You have 5 minutes.
Yeah. Okay. How are we doing on questions?
We have one question so far.
Oh, okay. Again, people can't ask about protected class status, whether it be about disability or in regards to, for example, national origin. Hey, where are you from? You can't ask about those types of things. Refusing to negotiate or make unavailable. Gee, sorry, we just rented the unit. You'll have to go down the street to so-and-so's units. Housing providers can't advertise in a discriminatory way, but they also can't make any statements regardless of whether it's up to renting the unit, selling the unit, whatever, in 6 months into a lease. If somebody makes a discriminatory statement 6 months into a lease, it's a violation of advertising provisions. If someone is filing a complaint of discrimination, the housing provider cannot retaliate against them, cannot intimidate their witnesses or threaten or interfere with that process. To file a complaint with HUD, you have 1 year from the last discriminatory act, and with the Human Rights Bureau, 180 days. And then if you're going to go into court, you have 2 years. HUD and HRB are required to try and conciliate the complaints throughout the investigations. And then, of course, as I mentioned earlier, there's always exemptions. Tribally owned and operated housing is exempt from the fair housing laws. Religious organizations and private clubs are exempt. And then there's varying breakdowns at the federal and state level based on the number of units and sleeping rooms. If you ever have questions about that, just give us a buzz. And then housing for older persons is able to deny based on familial status only. So that's a real quick overview of the laws. I hope it's helpful, and hopefully I have some time to answer a few questions.
Okay, sweet. Thank you, Pam. So I received one question, and that question was, under the Montana Human Rights Act, does the sex protected class only protect the male and female binary, or does it cover trans or non-binary individuals as well?
The state law covers only male-female. As I mentioned, I think there are local ordinances like in Missoula that add additional protections, but the complaints would have to be, if they're based on that, would have to be filed under the local ordinance. To date, there's no state or federal protections unless you're living in federally subsidized property. Then there are broader protections. Sometimes There's been a few cases where if a housing provider, for example, would allow lesbian women but not gay men, there could be an argument made there on sex to file at the federal or state level, and there have been some. In addition, there's been a few cases where a person moved into a complex, and upon discovering the person defined themselves as something other than, the male female binary, that the residents started harassing them based on that, and the housing provider did not act accordingly to prevent or minimize that harassment. So they've been able to link, say, if you're lesbian or you're gay, that's being male or female and linking it that way. But it's still pretty limited in how it can be pursued.
We have one more question. It's, do medical cannabis card holders have protections against housing discrimination?
No, because it's illegal at the federal level at this time. If and in fact, if you use it on site in federally subsidized programs, you lose the right to live in subsidized housing. I tried till the cows come home to argue that one, but not been successful yet.
Okay, and then we have one more question before we wrap up here. Can a landlord evict you for not renewing a lease? The lease had expired and tenant was on a month-to-month. The landlord said, I sent an email, but you never responded.
So a housing provider has the option to, continue with a lease, another 6-month or year lease, or most times it goes to month after that. If at the end of the lease you have, usually there's a clause saying within 30 days a lease would need to be renewed. And if you fail to respond to that, it can go month to month. And the housing provider has the option of saying, I'm keeping it month to month, or not going for a year lease. This issue's more under landlord-tenant law, but sometimes housing providers use landlord-tenant law to discriminate. So like for this example, if everybody that was white was able to say, geez, I didn't see that email, and the housing provider gives them a lease, but the native household, they say, nope, you missed your deadline, you're SOL. Then it could be discriminatory. Does that help?
Alrighty. Well, Pam, thank you so much. If you want to
Thanks,
end with some
everybody.
remarks. Yeah, alrighty.
Yeah, I appreciate everybody hanging out for this 50 minutes or longer. And I'm hopeful that if you have any questions, concerns, certainly input for me on how to do these Zoom presentations better, I would appreciate it very much. And hopefully it was helpful. Thank you.